injury cases and in comp cases, the law allows us to do it differently. We don't require you to put any money down, because if you had to give us the amount of money it would take for the work that we have to put into some of these cases, believe me, you couldn't afford it. And plus now here you are out of work or injured and can't do it. So contingency fees are what happens. And what those say is the lawyer basically is working along with you. And at settlement, at resolution, at verdict, at trial, the lawyer is going to receive a percentage of the total recovery that you're going to get. And for most people, it's an excellent bargain. In workers' comp in Rhode Island and in Mass, fees are capped at 20% of the gross recovery at time of settlement. In personal injury cases, there's no statute that governs it. Typically, over the years, the fee has been 1/3, 33 1/3%.
Although, we have heard that
if it goes into suit,
Yep.
sometimes it's 40% or
and some
even
places
a little bit
even
higher.
go even higher, up to 50%, I've heard, because if someone, let's say, is in an incredibly complex medical negligence case, and there's just a huge stakes and lots of experts and lawyers spending tons of money on expenses to put this case on, sometimes they're saying, well, that justifies a fee of even above 1/3. But the standard number that's still quoted out there in many cases is 1/3.
Okay. We do need to talk about the money. So there's a case. How do you decide settlement, trial? How do you determine what could possibly be a reasonable, equitable settlement? And how do you go about approaching that? We don't need a math course here, but if you could just itemize some of the kinds of things that you have to, mental gyrations and gymnastics to arrive at this.
Well, let's take...
Why don't you do the personal injury, then maybe I can add, if anything, and then we can talk about comp.
By way of example, we'll use one of the catastrophic cases we had. So we talked about developing that care plan, the case management care plan that the person's going to need for the rest of their life. What happens with that plan is there's a nurse or someone who's qualified to understand the nature of the injury and everything that needs to be done. She creates a plan that says you're going to need X number of dollars per month for in the case of the client with a quadriplegic, to see doctors, to have medical supplies brought in, and she goes through every medical supply that is needed, what doctor's visits are going to be needed, potential nursing home care, if that's ever where this is going to end up, and she prices all of that out. What we then do with that plan is we bring it to an economist to tell us how much money is needed to fund this plan. And we can talk later. Bob and I work with a fellow who will then, you can take these costs out and have it done what's called a structured settlement, where payments are made. And we can do that. And if we don't have enough time today, perhaps we can even bring in the fellow who we work with on that. So what happens is you then get a number for that plan. You also have a number you need to take care of the person's lost wages over the course of their time. Again, an economist is used. We hire an economist. We usually use a fellow out of Brown University or the University of Rhode Island who will give you a value of what the person's earnings are over the course of his employment. And the last piece really is pain and suffering. And that's the one that can be the most difficult to put a number on, which can also include loss of consortium, which is in the case of the person who was injured in the slip and fall, the husband. He's got to now care for her in a way he never should have had to care for this woman. What's the value of that? And if there are minor children, what's their loss of parental society and companionship with their parents? So those numbers are all put together.
You can assign a figure to that?
You try to quantify that,
Here goes that spreadsheet, okay.
Yeah, you try to quantify that. There's also a loss of enjoyment of life. Someone who's had a brain injury,
for
say,
that?
and maybe they're not in physical pain, at least that you can quantify, but they don't remember things.
Right. Their life has changed.
Their life is dramatically changed because they don't remember their wedding or the birth of their children. What value do you place on something like that? So that all goes into that last bucket of pain and suffering and all that goes along with that.
And you were going to address the workers' comp side of it briefly?
Yeah, I think it's helpful for people to understand. I tell people this a lot. In a personal injury setting, you don't get anything from the responsible party normally while your treatment and care is pending. Once you've gotten to as good as you're going to get,
plateau, whatever that is.
Yes, the maximum medical improvement is one term that's used.
Okay.
Well, once you reach that end result, only then can your lawyer put together a value of the claim, including all those elements that David described, and then present that to the insurance company, the responsible party. Hopefully, you're able to convince them that the right thing to do is to pay the claim, and that's when a claim settles. If you can't get to a reasonable amount, then eventually you go to a trial, and that claim is paid then. So I always tell people personal injury claims are paid at the end. Workers' comp is a pay-as-you-go system. If you have a legitimate workers' comp injury and the insurance company accepts it, they're paying you right now from day one. You're getting weekly benefits to help replace your wages. You're getting your medical bills paid for. So they're essentially taking care of what they have to take care of right along. You don't get pain and suffering in workers' comp, by the way. That's a big takeaway. It's no fault, but you don't get pain and suffering. So if the insurance company's paying you what they owe you all along, why would the case ever settle?
Good point.
Good question, right? The only time a workers' comp case settles is when the insurance company's responsibility to you looks like it's going to extend on for a relatively long period of time, a more serious injury. You can't get back to your regular job, or even a catastrophic injury where you can't do any job. And now they could be paying you, in theory, for life. So in those cases, sometimes you can get the insurance company and our party to sit down together and see if a lump sum settlement of that future responsibility makes sense for everybody. It doesn't have to happen, though, in comp. You can't force the carrier to do it. They can't force our clients to do it. It has to be a mutual process.
Then from a strategic standpoint, if someone's going along not making money, getting some insurance money, obviously not going to be what their former salary might have been.
Correct.
If the insurance company could string that along forever, that person is perhaps continually backsliding in their financial obligations at some point. Wouldn't that then put the pedal to the metal from the insurance company to say, let's settle now, you'll get some money, even if it isn't the whole amount that they should? Is that what makes a difference in whether or not you're working for the claimant? Is that what they call it?
Yeah.
So you end up...
Employee, petitioner. Claimant. It's used different terms in different states,
So how do you end up getting involved in working that out? I mean, the person you understand wants money and needs more than what they're getting on that one level of payout, but you also don't want to be short-sighted, I guess, if it needed to go to trial. How do you balance that? How do you work with a client with that?
It's really not a question of going to trial and workers' comp if they're already paying you.
Oh, that's right.
Because that's what you're going to get. And remember what happened was workers' comp was developed as the world became industrialized, as the United States became industrialized. And when people got hurt at work, the reason the system was developed the way it was so that you wouldn't have to go for a long period of time without income. So that's why they traded off the right to sue for pain and suffering and all of that. So it was originally designed to replace the income you were losing. It's gotten taken away a little bit over time.
It's supposedly, it's supposedly designed as almost an easy, quick on, easy, quick off system. The vast majority of people that are hurt on the job, they recover. And within months, weeks sometimes, right? They go back to work. They go back to the regular job. Workers' comps paid them, helped cover them, kept them afloat during that time of disability, paid their bills, and now everybody's back to normal. Where it gets more complicated is when the injury is more serious. The issue about returning to work seems uncertain or definitely not going to happen. Then other issues have to happen. But even in workers' comp along the way, we talked earlier about choice of physician. Very, very important. And you get to the wrong doctor who really doesn't specialize in what you need. And that can be a problem, and then you have to make sure the benefits are maximized for these people. So like you said, they're taking as small a hit as possible so they can keep paying their bills.
This has been a very important and very interesting topic. I had hoped that we'd be able to talk more about the actual issue of settlement, lump sum, and all of the financials that go along. I think that we probably need to cover that in our next segment. We hope that you'll stay tuned. And as we always ask you, if you have specific questions, please feel free to email us at legalmatters@fullchanneltv.net. Thank you, Bob. Thank you, David.
Thank you.
Thank you.